Well, good morning, everyone. This is George at the Office of Open Records. Glad to be here, and it looks like everything is working. We tried to have a webinar 2 weeks ago, and if you recall, if you were here, we had some major technical issues where absolutely nothing was working. It was very frustrating because first time in 5 years, we actually had to cancel a webinar because of some technical issues. And myself, Dylan, and Michelle were just racking our brains what was going on. And every time we tried another workaround, something would happen that everything would just crash, and we weren't having any luck, and finally just had to throw in the towel. Um, Dylan then discovered that one of the cameras had stopped working, which is interesting because we don't use cameras on this particular webinar, and it was causing a conflict with all the other devices. And as soon as you unplug that camera, everything would work. So we've since replaced that, and it looks like we're good to go as far as the presentation here. But we apologize. We tried our best to figure out what was going on, and like I said, we just were completely out of luck. But the next day, Dylan got it all sorted out with the tech people, and we're back online, and I was able to do a webinar the following afternoon with an outfit out in the western part of the state. So yeah, we're just, like I said, we apologize for all that and the inconvenience, but we're glad to be back where we should be. Okay, so you are here today to listen to me talk about right to know law and payment issues. A couple preliminaries before we dive into it. If you're not familiar with these webinars, it basically is a PowerPoint presentation with me talking in the background. The PowerPoint itself is available on our website. You would go to the training tab, scroll down, and you'll find all the presentation materials that we use, and you're welcome to download those for free. Use them for your own future reference, or if you have local training or something like that, if they can be helpful, please have at it. Also, this presentation is being recorded, and we save the recordings. And if you would like a copy of it, again, either for your own future reference, or maybe you have a colleague or coworker who couldn't make it today, and you think it would be helpful for them to have a copy of this, they are available. You would reach out to the office, and they can, usually what happens is there's a file sharing service where they can provide you with a link, and you can sit at the convenience of your own computer and watch that link. If for some chance that wouldn't work out, you can end up sending in a flash drive, and they'll manually copy the recording over to the flash drive. You would include a self-addressed stamped envelope for return, and that works out as well, but there is the file sharing. Okay, so if you have questions today, feel free to weigh in. You can type them in the meeting chat feature. Couple things that I would ask. First is that we are talking about the right to know law and payment issues today, so try and keep your questions on point related to that topic. Also, the shorter you can keep your questions, the more direct, the better. That would, the reality of the situation is it can be awkward for me to sit here and read several paragraphs that you may have typed in and then formulate an answer and take up everybody's time while they wait patiently. So the shorter, more direct you can keep your questions, the better. If by chance it looks like you have a question about something specific to your organization, or something that's a little more complex than the norm, we'll do one of two things. We'll wait until the end of the presentation, and I'll come back to it and address it there, or we can take the conversation offline. You can reach out to the office. One of the admins that regularly answers the phone might be able to help you out, or they'll direct you to me or one of the attorneys who can try and get you steered in the right direction. Okay, so we'll do our best to help you out here. But all that being behind us now, let's jump into the presentation. right to know law, and payment issues. And, where does this all come from? Well, if you look at the right to know law itself, which you can find on the website, again, download it for free. It's on the main tab for right to know law. It's not a hard law to read. For the most part, it's written in common English, and it's not a very long law per se. But you'll find in there, specifically with Section 1307, that it authorizes the Office of Open Records to establish a fee schedule. And that fee schedule is also posted on our website. It's reviewed every 2 years. I think it's coming up for review January 2023. And when we do that, we use social media to alert everybody that the fee schedule is under review, and that if you have any comments or questions about what we're doing, please contact us with your ideas, with your concerns. We do listen to you, and in the past we have made changes as a result of comments that the fee schedule. What I want to emphasize here is that don't just look at the fee schedule itself, but go down to the footnotes, because the footnotes include the details, the explanations that really help when it comes to how you apply the provisions that you find in the fee schedule. There's always exceptions, and there's always exceptions to the exceptions. And the fee schedule relies on those situations where, we had to dig in a little deeper, or where we rely on case law to help explain how the fee schedule applies in specific scenarios. So yeah, take a look at the footnotes to get a clear explanation as to how the fee schedule works. And basically, what it comes down to is that an agency can charge up to 25 cents a page, single-sided black and white, 8.5 by 11 or 8.5 by 14. Now, that changes once you see the asterisk there. That changes once you get above 1,000 copies as a response to a request. It drops to 20 cents a page. Okay. And then if by chance you're providing, if it's been requested and you're providing color copies, then that goes up to 50 cents a page. Single-sided color, 8.5 by 11, 8.5 by 14. Now let's say that, as a result of the records that have been requested, they're unusual sizes. And here, practically we're referring to blueprints is usually what it comes down to. If you're providing an unusual size copy, then you can charge what is known as actual cost. And I'll get into that a little bit as to what an actual cost is. Okay. But, bottom of the slide, bold, red, larger print, read the footnotes, okay, when you look at that fee schedule, because that will give you a true explanation as to, what it all means. Okay, moving on here. Pass-through costs, actual costs, like I promised. Okay, actual costs are those that are incurred and can be documented, and then you can pass those on to the requester. Let me go back to the example about the blueprints, okay? Let's say someone requests a public record that, is a blueprint. It could be, new plot plans for a subdivision, just as an example. So your agency doesn't have a large-scale copier. You end up going down to Staples or Kinko's or the local architectural firm and get a copy of that blueprint made in order to provide it in response to the right to know request. Okay, well then whatever Kinko's, Staples, or the architectural firm charges you and can be documented, you can then pass that cost on to the requester as part of the invoicing process. Okay, so that's what we mean by a pass-through cost. Postage is another example. Let's say the scenario is someone requests a bunch of hard copies and they want them mailed to them. Okay, so you make the copies and you can charge up to 25 cents a page, but then you take all those copies and put them on your postage meter prior to mailing out. And it says, okay, to mail to this particular zip code, it's going to be $3.15. I just use that as an example. Well, because that is an actual documented cost, you can add that on to your invoice. So in addition to what you're charging for the copies themselves, you add on that actual documented cost, the postage. Okay. And then periodically, this is one that we run into, but quite frankly, I haven't seen it in a couple years now, so it might be removing it from the presentation. And this would be analog recordings. This usually occurs when someone requests copies of a recording made of a public meeting. And the agency is still using a cassette deck or a micro cassette deck, and they don't have the hardware, the technology to make a copy of the cassette. Remember those dual cassette decks that, I think mine broke down 20 years ago and you couldn't replace them and no one was using cassettes anymore anyway. Everything had gone over to CD and DVD. So, you just end up throwing it all out. Well, those things aren't around anymore, but you can still find them with certain sound studios, technology shops, and the like. And it is still possible, if you hunt around, to get cassette decks copied, but it's going to cost you. And what it comes down to is that they're going to provide you with a bill. So you can take that bill and say, look, in addition to the cost of the cassette itself, if you can still find any blanks, we're going to charge you what it cost us to make a copy of this cassette deck. So that also is a pass-through cost, which you can add to the invoice. Now, I want to caution you because there was a court case last year where the court kind of showed that it is leaning towards, it's relying on language in the right to know law that limits what you can charge for. And they're relying on that language to say that, look, in certain circumstances, you cannot charge pass-through costs. So I think as it stands right now, legally you can, but just be aware and pay attention to any notices coming out of the OOR about this issue in case we do see new court language that is kind of narrowing what agencies can charge for copies. Okay, it's getting tighter, and it's just something that we've recognized since seeing that court case last year. And then we come down to storage media, and this would be, for the most part, for practical purposes, flash drives. And next slide, I'm going to talk about this in more detail. As a matter of fact, let's go to that slide right now. We review this, or we regard this as a best practice. Now, let's say that someone requests a whole mess of electronic files and they exceed the size limits that the agency's technology can send through their, electronic internet connections. For instance, our office has that. It's put in place by the IT security people, where I think it's like 10 megabytes. We cannot transmit files greater than 10 megabytes. Now, there's a couple things. In the past, our administrative staff is like broken down so that we send multiple emails with attachments, or we simply say, look, this has to be done on a flash drive. So send us a flash drive and we will in turn copy the files over and then mail them to you. That's the only practical way we can do this. And this happens with the agencies a lot too. Now, in the past, agencies have kept a supply of flash drives, and then they turn around and charge the requester the cost of the flash drive. Okay, and it becomes very cumbersome and just, a pain. Um, so this was brought to our attention by a couple agencies that started doing this. It's like, look, if you're requesting a large group of electronic files, send us an unopened flash drive, and then we will copy the files over to it and return that to you. That way, we don't have to charge you for it, go through all the invoicing, and we don't have to keep a supply of flash drives here at the office and so forth and so on. And it works quite well. And the security people like it because they say, send an unopened flash drive to us. And that way, there's a greater chance that there are no viruses on the flash drive because that's their concern. And what they'll do is first, they'll copy the responsive files over to a laptop and then unplug or disconnect the laptop from their network. Then they'll plug the flash drive into the laptop to copy the files over. And if by chance there is a virus on that flash drive provided by the requester, the virus protection software on the laptop picks it up without any fear of it infecting the network for the agency. Okay. It works out really well. And I want to emphasize that there's absolutely nothing in the right to know law that requires you to do this, all right? But this is simply something that was brought to our attention. Our office has adopted this practice, and it works out well for us, although since then we've kind of migrated over to file sharing. Initially, the IT folks said, no, we're not going to allow any sort of file sharing because of fear of getting viruses. Now they're confident with the file sharing software that the system is protected from that. But for instance, if you wanted a copy of the recording that we're generating here today, because of the file size, we used to say, send us a flash drive. And also, there are some agencies that still will not allow their staff to access file sharing sites. So, flash drive is the only way you can get these copies. So, this is what we do. Like I said, I want to repeat, it's not a requirement of the right to know law. It's simply something we found that works for us, and you might want to take a look at it as a best practice. Okay, so moving on again. What can't you charge for? Well, you can't charge for employee labor, whether it be an hourly cost or any sort of fixed fee. Sometimes we still find agency websites where they say, to get a response to a right to know request, we're going to charge you $20. That's inconsistent with the law, and you cannot do that. And if someone brings it to our attention, we will reach out and explain that to you. And if by chance there's a dispute that leads to an appeal, the agency's more than likely going to lose that appeal because you cannot charge for employee labor. You can't charge for legal review, whether it be, an internal solicitor or any sort of outside counsel. It's simply considered the cost of doing business in government as it relates to the right to know law, as you would for any other processes that your agency would be responsible for. Occasionally, we still see a right to know processing fee. Like I said, that $20 fee that some agencies may attempt to charge. Some agencies would put there, if we have to redact anything, like blacking it out, we're going to add on a $5 charge per page or something like that. Again, you cannot charge for redacting per se. You can't charge for scanning. And this comes up periodically, not as much as it used to, but we would get an email or a phone call from somebody who said, look, if I have to scan a record in, I'm going through the same physical process that I would if I were making copies, and it's the same wear and tear on our copying device. So why can't I charge for scanning? Well, number one, there's a very good chance that you don't have to scan at all, and I'll explain that here in an upcoming slide. Um, but number two, you cannot charge for electronic records, and we'll get into that. And scanning is creating an electronic record. So you'll see the logic behind this. Finally, I probably should take this out, but it's only come up twice. You cannot charge for electricity. And yes, we've had the question. And my first response to them is, how are you going to figure out cost? But yeah, you can't charge for electricity. Finally, you cannot charge for electronic records, like I said earlier. That would include emails, Word documents, Excel spreadsheets, various database files. If it's an electronic record, you cannot charge for that. And then if there is any dispute over the fees that are being charged by an agency, the requester can appeal that to the OOR. And if you go to our website and you would go under the appeal database search feature, you can, for instance, in the random text string, I would put in the word fees, and it will bring up every appeal final determination rendered by the Office of Open Records that dealt with a dispute over fees. And there's a couple dozen in there, and you can read those and get an idea as to how the OOR has ruled on these fee-based disputes. It goes both ways. It's fact specific, but the point being that if there is a dispute over fees, if a requester feels that the agency is out of line or inconsistent with the right to know law, they can file an appeal based on that dispute, and we will rule on that. Okay, this is an important slide. It's, pardon me, it could be the most important slide that we have in this presentation. And it refers to Section 701 and the idea of medium. Now, to paraphrase, Section 701 basically says that a record is provided in the medium in which it exists. All right, so what does that mean? Let's translate that into English. And it comes down to, is the record in hard copy or is it electronic? And how is it maintained by the agency? Do they maintain it hard copy, or do they maintain it electronic, or possibly both? So let me throw out an example here. Let's say that we're talking about building permits for a borough. And the whole process is paper driven. Everything is hard copy. Okay, the application gets mailed into the office, forwarded to the zoning officer, or the codes enforcement officer, I should say. And he or she reviews it. Any correspondence going back and forth is by mail, and so that there's a hard copy record kept. And when approved, the building permit goes out through the mail and a copy is kept. And everything is kept in a file folder stored in a file cabinet. Okay, so everything is hard copy, nothing electronic. Then you receive a right to know request. It comes in by email, and it is requesting copies of building permits. Okay, and they want them sent to them electronically because it's easy, and it's also free because you cannot charge for electronic records. But the dilemma that the requester faces is that the agency doesn't have them in electronic medium. So based on this language in Section 701, the agency does not have to provide an electronic copy. Remember when I said, when I went back to the other slide and the reference to scanning? Well, the agency is under no obligation to scan in the hard copy records in order to respond to this right to know request, because that would be converting the record from one medium, hard copy, to another, electronic. Section 701 says you don't have to do that. Now, if by chance there were an electronic copy of the record, then the agency would have to provide it, and it cannot charge for electronic records. We still periodically find agencies that, even though they have the electronic record, they say, we're only going to provide them hard copy and we're going to charge you for them. You cannot do that because you have an electronic copy and because it has been requested as an electronic copy, then that is how you must provide it. And like I said, you cannot charge for electronic records. Okay, so that would be the impact on scanning and printing. If you want to turn this around, let's say that someone has requested hard copy versions of electronic records. Technically, you would not have to print those out because, again, that would be converting them from electronic to hard copy in this particular instance. And, very rarely we see that, but, that's how you would apply this particular section of the law. Okay, so we've talked about medium. What about format? Okay, because format is something different as it relates to the right to know law. Medium is hard copy versus electronic. Format is the version of the electronic record and how it exists as an electronic record. And with case law, here we're specifically referring to Excel versus PDF. Okay, now if you're familiar with this, then you'll know what I'm talking about. If not, I apologize, but it's a germane issue with the right to know law. Someone submits a right to know request and they say, I want a copy of the Excel spreadsheet. And the agency, this is an evolving area of case law with the right to know law. So I want to, just put it on your radar screen. Okay. The issue is that the agency does not provide it in Excel, but rather as an electronic PDF copy. Okay. And they do that because they have some fear that if they give the Excel sheet itself, it will show the formulas that are used to arrive at what appears in the cells. Plus, there is a fear that someone will alter the spreadsheet for potential misuse. So they provide it in PDF. Now, initially, the courts said the right to know law requires that the agency provide a copy, and PDF is in fact a copy. Therefore, agencies are allowed to do that. But in recent years, the courts have changed. The logic has evolved so that where we're at today, if someone specifically requests a copy of the Excel spreadsheet and they use, the actual term of the software that's used to develop the spreadsheet, because there are other spreadsheet applications other than Excel. If they use the actual term, then you must provide the spreadsheet in that format. Okay, so if I say I want the Excel spreadsheet, then you give it to me as an Excel spreadsheet, not PDF. If I say I want, gosh, I forget the term that Apple uses, and I have a MacBook, but I also have Excel on it, so I forget. There is a spreadsheet application, okay, that is proprietary to Apple, that if I asked for that, that Mac version, as an agency, I would have to give that Mac version of the spreadsheet. But if I just use the term spreadsheet, then the agency, at their discretion, could provide a PDF copy. Okay, so that's where case law stands today. It is evolving. We're keeping an eye on it to see, just how far the court goes with this. They may have gone as far as they want to, but it's something you should be aware of and keep in mind that it may change someday. Honestly, I think the fear about people misusing the spreadsheets once they're provided, first offhand, that legally that falls outside of the right to know law. And secondly, I've never heard of that actually happening. Okay, I've never heard of someone getting an Excel spreadsheet from an agency through the right to know law and then turning around and misrepresenting um, by changing the spreadsheet itself. All right, so I think that might be one of those unfounded fears. You know, you're worrying about something that's not going to happen. Okay, and then we get into proprietary formats. This comes up periodically, mainly with law enforcement, because they might go out and purchase a software package that does not allow hard copy printing, and there's no way to convert the files to a generic format like ASCII or CSV or PDF or something that can be provided through the right to know procedure. The only way you can read their files is if you have a copy of that proprietary software, which you're not going to get because you're not a law enforcement agency. Okay, it's all because of security reasons. In those instances where there is no way to generate a record that is in a readable format for a layperson, the agency can deny the request because there's no way to produce the record. Okay, and they're under no obligation to pay to have the files converted. All right, and chances are there's going to be other right to know exception issues that would prevent access to those files anyway. But we have run across that a couple times. Just again, another thing that you should be aware of. Okay, moving on. Redaction costs. Now, you cannot charge a redaction fee, meaning that if we have to redact, we're going to add on an extra $5 per record. However, there may be instances where the result of the redaction ends up creating a fee that the requester is going to have to pay for. Okay, and this results when the agency is providing a record that is otherwise considered public, but there might be some piece of data that is otherwise considered sensitive or confidential on that otherwise public record, like a social security number or home phone number or a personal email address, something like that. Okay, so they end up manually redacting that sensitive piece of data. And the only way you can do that is, let's say it's an email with a home or with a personal email address on there. You have to print it out. Then you take out your Sharpie and you black out the sensitive piece of data. Then you scan it back in so that you can provide the otherwise public record with the redaction. In that scenario, you can charge for the piece of paper that you had to print out in order to effect the manual redaction. Okay, so that's how that works. Now, many agencies have electronic redaction software. Initially, there were fears about security. Even here at the Office of Open Records, we had a requester who was able to basically hack the redaction software and see what was behind the redactions. But this was many years ago. Since then, for instance, the Adobe Office Suite contains redaction software, and that's what our office uses now. And it's certified as secure by the FBI, along with others that you can purchase out there. So our position is, look, at this point, you're not under an obligation to use the redaction software, but as a practical perspective, you should be using it. Okay, no legal requirement, but if you have electronic redaction software, that's how you should be using it. Number one, because it's easier. Number two, because it's more secure. Number three, because then you don't have to worry about charging. And you may think, gosh, if there's some way I can stick it to this guy by charging him, that's what I'm going to do. the problem is that it's usually more work than it's worth in order to do that. So use the electronic redaction software, save yourself some time and save yourself the whole invoicing process, and it'll work. What about inspections? Because if you remember, under the right to know law, you have the right for copies or you have the right to inspect the originals or copies of the originals, whatever. So let's say I submit a right to know request and I want to come into the office to inspect the records. Okay, well, first offhand, the agency is in the driver's seat when it comes to inspections. Okay, they determine when during normal business hours it's convenient for them to have the requester come in to inspect the records. But again, let's go back to that scenario where the hard copy record, it is public, but let's say there's that social security number on there, so it needs to be redacted. You generate a copy. All right, so now you can charge for an inspection, which is really unusual. And my recommendation is that whenever you're going to assess a charge, reach out to the requester. Let them know beforehand that, hey, given the specific facts of this, we're going to assess a charge. Are you okay with that? All right, and they may back out. Okay, they may say, no, I'm not paying any money. So then you consider the request withdrawn. But, if they do, then great. Everyone's on the same page, no problems. All right. And again, when we talk about appeals, redactions are in effect a denial because take a step back. You are denying access to a portion of a public record. So when you respond, when you're granting the request, but saying, there's redactions there, legally, you need to explain what's behind that redaction. You would need to say there is a social security number that we have blacked out or that we have electronically redacted. Okay. You need to communicate that with the requester in order to meet your legal burden. So if you're doing that and it results in a cost, well, no. I'm getting ahead of myself. If you're doing that, whether there's a cost or not, okay, that is a denial, and redactions can be appealed. If you're familiar with right to know law and cases, go back a couple years to the medical marijuana issue, and there was a very big case with the Department of Health and a reporter over redactions for medical marijuana. I think it was dispensers or growers, and the applications that they submitted to the Department of Health. Okay, it was all about redactions. So if you want, to know everything there is to know about case law and redactions, start there and go to our, final determinants database or go to the case law index, and you'll see some interesting decisions there specifically related to redactions. I'll spit it out here. Okay, let me get a quick sip. Yeah, and let's talk about charging fees. Here we're, splitting a hair, question. If a requester wants a document with his own social security number, I assume redaction is not necessary. Actually, Chris, I would recommend redacting it because you're saying it's a public record that everyone can have. And even though you're providing it to the requester, the guy with his own social security number on the record, because it's public, I would play it safe and I would redact that along with any other sensitive information. Yeah, that's a good question. And yeah, you'd be surprised how much it comes up where someone is using the right to know request to request a record about themselves. Okay, and you have to remember that it is a public record that the person is requesting because they're using the right to know process. So even though it might be, specific to them, it may not be a public record, or a piece of data on there may not be public. So you want to be judicious in how you use the redaction tool. Okay, good question. Okay, so charging fees, Section 901 of the Right to Know law. Again, paraphrasing, the Right to Know law doesn't really address the process. What it does say is that all applicable fees shall be paid in order to receive access to the record requested. Just break that down in English. It basically means first you pay, then you get the record, okay? And that's how it's been applied throughout the years with, how we've regarded this issue. So let's walk through the process. First offhand, okay, someone submits a right to know request and you end up granting it. Now, the first question you have to answer is prepayment applicable? Meaning, is the response is the cost of the response going to exceed $100? Because if it does, the agency can demand payment for the entire response up front because it exceeds $100. I like to refer to this as a security deposit. The right to know law has this feature in it so that the agency doesn't get stiffed for a big response that the person may ultimately balk on. So you can say, because your response is going to exceed $100, we're going to demand that you provide us with a check for the entire amount. And usually it's an estimated amount that you settle up when it comes time to provide the actual records. Okay. So you have that check, then once the check is received, then you begin processing the response. Okay, but what about if it isn't, if it doesn't exceed $100? Well, then you have to begin processing right away. And you can provide an invoice. Now, this brings up another issue because there is a common misunderstanding. All of the deadlines built into the right to know law refer to when the agency must provide a response. 5 business days, must respond within 5 business days. Or you can take the 30 calendar day extension, and then you must respond by the end of the 30 calendar days. Okay, note that I am using the word respond and not the phrase provide records. The right to know law does not say you must provide the records in 5 business days. It does not say you must provide the records at the end of the 30 calendar day extension. It says response. So hypothetically, you grant the request by providing your response within the deadline. And with that, you can provide an invoice saying it's going to cost you $30. Again, hypothetical. It's going to cost you $30 for the responsive records. Send us a check, and when your check clears, we will provide you with the records. And typically it's within a reasonable period of time. Again, very subjective, but you kind of know what's reasonable and what's not. Okay, so once you receive payment, then you process the payment, meaning you can wait for the check to clear, and then you provide the responsive records. Okay, everybody see how that works? It's not providing the records within the deadlines, it's providing the response within the deadlines. Okay, and then as far as that prepayment goes, note the other asterisks there, it's at the agency's discretion. Okay, the agency is not required to demand the security deposit, but you have that tool available to you if you want to use it. All right, and then the right to know law, like I said, it doesn't speak to the whole invoicing and collections and the like, okay? There is some case law that deals with it, but it's very limited. So the agency has a fair amount of discretion in how you invoice. Some agencies don't invoice at all. They say, hey, here's the records. When you have a chance, send us the $5 or whatever. All right, and they don't go out of their way to collect, or they may choose not to charge at all. For instance, our agency, the OOR, very rarely charges for the records that we send out, but mainly that's because for the most part they're electronic. Okay, let's talk about record discard. You know what? This happens so rarely anymore that I'm not going to get into the details of the potential scenario. If you're curious about it, take a look at Section 905. But I think the useful purpose of this slide is, what if the requester incurs a debt? Okay, what if they're provided with records, there's a cost, but they don't pay that cost? What it comes down to is that the agency can withhold processing any further right-to-know requests if there is an outstanding debt from that requester. Okay, so let's say that you send them a bill and they don't pay, but they've been given the records, or, that if any way that debt is outstanding. Okay, so they submit a second right-to-know request. You can deny that right-to-know request based on non-payment of the previous request. It can be an entirely different set of records. There is no statute of limitations, okay? It doesn't go away after a year, doesn't go away after 5 years, all right? That debt, as long as it is outstanding, you can deny it. However, it is a denial, and they can turn around and file an appeal based on that denial. So the agency needs to make sure all I's are dotted, T's are crossed, communications with the requester, the basis for the debt, how they arrived at the fees, et cetera, et cetera. Okay. And if you want to read up on it, like I said, you can do a search for the term fees in our final determinations database, and all those decisions will come up. Okay, and like I said previously, the right-to-know law and case law, there's nothing out there on collections activities. Every now and then we'll get the question, how do we collect on these debts? Well, how do you collect on debts for other processes within your agency? All right, and maybe apply that to the right-to-know law. But you're not going to find precedent from our office or any case law on that. Okay, I've kind of been hinting at this, and it's no surprises, okay? There's nothing in the right-to-know law. Interesting that some people still don't get this. Nothing in the right-to-know law that prevents an agency from reaching out to a requester to discuss the costs that are associated with a request. Meaning that if you get the request, you do a quick calculation, it's just 30. Pick up the phone or send out an email. We've estimated $30. Are you okay with this? Most requesters, legitimate requesters, are willing to pay a nominal fee for public records that they need to solve whatever problem they have. It's the handful of people that are misusing the right-to-know law that aren't willing to pay any money. All right, so you reach out, make sure everybody's on the same page, and then they say, yeah, I'm okay paying it, and then you proceed with processing the request, making the copies, doing whatever you need to do. Conversely, a requester on their request can say, look, if this is going to exceed $10 or whatever figure they put in there, please reach out to me first. All right. And when we have seen that and the agency has ignored it and then sent a bill in excess of $10, we've ruled in favor of the requester. We said, look, they have reasonably reached out to you and said, $10, you notify me first. And if you give them a bill exceeding that $10 and they balk at that and file an appeal, you might be out of some money here. But, please be careful about this. The point being, communication is good, okay? If there's any sort of ambiguity, any sort of questions, talk to each other. Make sure everyone's on the same page, because it will invariably save you a lot of work, a lot of headache, a lot of misunderstandings in the long run, okay? And if there's any way we can save ourselves work that we don't need to be doing, like processing appeals, that's a good thing. All right. Now, an agency cannot force a requester to tell them why they're filing a request, but sometimes just knowing that might help you identify responsive records. So again, nothing is wrong with reaching out to a requester. Look, I kind of have an idea what you're asking for here, but I suspect maybe you're barking up the wrong tree. Do you mind telling me why you're looking for these specific records? And the person, if they sense that you're working with them, they'll tell you, well, I have some tax issues with my business in the borough. The IRS is saying I need this record. I'm not sure what they're looking for. So I submitted this big right to know request. And then working on the agency side, say, oh, we've encountered this before. I know exactly what they're looking for. It's this document. I can have it ready for you this afternoon. All right. Well, right there, you saved everybody a lot of work, a lot of time, and probably a lot of costs. All right. The right to know law says you can't force them. The right to know law does not say that you can't ask. All right. And sometimes by simply asking, you might save yourself a lot of work. Okay. In red, in bold, communication is good. Okay. All right. This comes up periodically. I'm jumping around here, but 60 calendar days. Question has come up. 60 calendar days and the agency can dispose of the records. When does the 60 calendar days start? Okay, you've read section 905. All right, well, let's talk about that then. Okay, the 60 calendar days start when the agency has responded to the request. So in that particular scenario, you've granted the request. Everyone has agreed that the person is going to come down to, Borough Hall, pick up the records and pay for them then. All right. So that's when the clock starts ticking, when the agency has granted the request and communicated that to the requester. All right. Then if after 60 days they haven't picked up the records, you can dispose of the records because you've done everything the law requires you to do. And the debt is still there because you did generate the responsive records. So they still owe you that money. Okay. That's how section 905 works. Okay. All right. So moving over to section 1307C, certified records. It says that the agency can charge $5 per certification. All right. Well, the certification, first offhand, we need to explain that the agency is only certifying that the copies they are providing are true and correct versions of the originals, meaning that the copies have not been altered in any way. You are not certifying the provenance of the records themselves. They are considered self-authenticating. Provenance, if you work in law enforcement, you know what I'm talking about. It's the chain of custody. All right. You're not saying that what is on the record is true and correct. You're only saying that the copy is true and correct. That is what you're certifying. Okay. And then for example language, go to our website, look at the Agency Open Records Officer Handbook or Guidebook. And in there, again, another resource you can download for free. In there, you'll find sample language to use on your certifications. And you can charge the $5 for each certification that you provide. Okay. It comes up now and then. Usually it's when people are requesting records to right to know that ultimately are going to end up in court. They've got a lawsuit going on for whatever reasons. They need records, so they need a certification saying that these are true and correct copies. Because otherwise they would need to provide the originals. Okay. Another one that comes up are transcripts. I haven't seen this recently, but it does come up periodically, referring to section 707C transcripts. Okay. What the law says, and this usually refers to, an adjudicatory body like a zoning hearing board, or, codes enforcement, something like that. Okay, question has come up. Are we allowed to charge the requester mileage to drive documents to Staples? No, you are not. Okay, that's considered the cost of doing business. But if the copying service charges mileage to come to your office to pick up the records, go back and make copies, and then deliver them back, that becomes part of the invoice provided by the copying service, which you can then turn around and charge. Okay, so, again, I told you to be careful about this because it's an evolving area of case law, and that might raise some eyebrows, but legally in the past, you've been able to do that. All right, if they have that sort of service. Otherwise, you cannot charge for your mileage. Again, it's just considered cost of government doing business. And I see you put an exclamation point behind your thank you. So be careful, okay, with how you might use that. Okay, transcripts. How this works, okay, it's a little convoluted, but there are two tests that need to be solved here. The first one, in order to charge for a transcript, is that all appeals need to have been exhausted. Okay, you're talking about a hearing board, an adjudicatory process, which, if the appellant is not happy, they can appeal this up through the courts. And you reach a point where all appeals have been exhausted. Then and only then, the agency can treat the transcript as a public record accessible through the right to know process. The second part of the test is that the agency must have it in their possession because they don't always pay for a transcript related to an adjudicatory process. Rather, they will rely on the stenography, the stenographic service, maintaining a copy for them because they have paid a flat fee. Maybe it's a contract or they pay an hourly rate for the stenographic services. If either of these two tests have not been satisfied, the way that a requester gets a transcript is that they have to go to the stenographic service and pay whatever they charge for copies. Every so often, the tests have been satisfied and the agency will have a copy of the transcript. Okay, then they can charge what the right to know law allows, the up to 25 cents a page. And the stenographic service, either in their contract or they get wind of it, will turn around and say, oh no, they have to come to us and pay us what we charge, which is usually a couple bucks per page. Our office has said, no, at this point, because of the language in the right to know law, it is a public record and the right to know fee schedule applies. And we tell the stenographic service that's just tough. And it's never been appealed. So that's where the law stands now. But it's the result of this two-part test, okay? If either part has not been met, then it defers to the stenographic service, okay? So that's how that works. All right, I think, yes, we are at the end of the presentation, right on schedule. Good questions, but if you have any more, now's the time to get them in. In the meantime, I'm just going to refer you to the OOR's website. You've heard me say it, best government website you'll ever encounter, updated 6 days a week with new decisions, new information on the right to know law, the Pennsylvania Sunshine Act, which is also known as the Open Meetings Law, resources for citizens, resources for agencies. If you are an agency open records officer joining us today, I referred to the guide there, 78 pages. You can download it for free. If you're interested in the legal side of this, let's say you're a solicitor, we've got the final determinations database. We've got a case law index, which summarizes court actions on right to know law issues. A very good resource to take a look at. Everything is searchable. If you're looking for an agency open records officer, we've got a database there that you can go in and search particular municipalities. All kinds of information available to you, training resources. Feel free to reach out to the office with your questions. We can't answer requests for you. We cannot speak to active appeals, but we can steer you towards decisions that we've made in the past where the factual scenario is very similar. And, after 30,000 and counting decisions, there's a good chance we've seen it all. Not everything, but close. Okay, so we can point you to court decisions that will provide answers for you. If you are a real geek about the right to know law and agency transparency, you can subscribe to our Twitter feed where every morning at 7 a.m. we will wake you up with a tweet that gives you all the decisions that were rendered the day before, let you know about those court cases, training that's going on, et cetera, et cetera. And then finally, if you want to reach out to the office with a phone call or an email, please feel free to do so. We've got a crackerjack administrative staff that will, again, get you steered in the right direction, and will help you out as best we can. So I want to thank you for your participation today. Good group of questions. We'll be back in 2 weeks with another webinar, and we're glad to see everything's working today. Somebody had some sound problems. I didn't have time to respond to it, but basically, when someone is having like a sound issue, what we recommend is log out and log back in real quick, and that usually takes care of it. Okay, it's usually on your end. All right, but thanks again. Stay safe out there. Everyone have a good day. Yeah, all our webinars are scheduled for days at 10 a.m. You can use the same link as you used today. We try to recycle the same link for everyone's convenience. Okay, so I'm going to sign off now. Take care and have a good rest of the day.